Welcome back to the Love Train Nation. I'm BobbieD, and today we'll be discussing which visa is more suitable for you, fiance or spouse. We'll also provide some tips that will help you in submitting your application to the USCIS. It's important to understand how your decision will impact you and your partner. In this video, we'll explain the differences in processing times, fees, eligibility of foreign children, requirement for a financial sponsor, the consequences of any arrest or conviction. We'll also share with you some tips and resources on how to create and submit your application to U.S. immigration. Let's dive right in. K-1 fiancé versus CR-1 spouse visa, which is better? Every year, U.S. immigration receives about 30,000 spouse visa applications and at the same time receives about 30,000 fiancé visa applications. Unfortunately, there is no easy one-size-fits-all answer. What is better for you and your partner depends on your particular and individual situation, your objectives, and your preferences. Tips: 1. Gather all the necessary documents before you start filling out the forms. This includes your passport, birth certificate, marriage certificate, if applicable, police clearance certificate, and other supporting documents. 2. Fill out the forms correctly. Make sure you fill out all the forms correctly and completely. Any errors or omissions can delay your application or even result in a denial. 3. Paying the fees. You will need to pay various fees throughout the application process. Make sure you have enough funds to cover these fees. 4. Submit your application. Once you have completed all the forms and gathered all the necessary documents, you can submit your application to U.S. immigration. You can submit your application online or by mail. 5. Track your application. After submitting your application, you can track its progress online using the USCIS Case Status Online tool. 6. Get help if you need it. If you need help with your application, you can contact a qualified immigration attorney or an accredited agent representative. Foreign children, immediate relative, IR, visas. Foreign children who have a U.S. citizen parent, either by birth or through the immigration process, may be eligible for IR visas, such as IR2 for unmarried children under 21 or IR3/IR4 for adopted children. Fees. Visa type K-1 fiancé visa costs $535 for the I-129F petition and $265 for the DS-160 visa application fee. Medical examination, $200 to $500. Translation of documents, $50 to $100 per page. Filing fees for adjustment of status, $1,225. Attorney fees, $2,000 to $5,000. Total estimated cost, $3,225 to $7,025. Spousal visa, $535 for the I-130 petition and $325 for the DS-260 visa application fee. Medical examination, $200 to $500. Translation of documents, $50 to $100 per page. Filing fees for adjustment of status, $1,760. Attorney fees, $2,000 to $5,000. Total estimated cost, $3,620 to $7,120. For a spouse, CR1 or IR1 visa, U.S. citizenship or permanent residency, the financial sponsor must be either a U.S. citizen or a lawful permanent resident, green card holder. Income requirements. The financial sponsor must meet the minimum income requirements set by U.S. immigration authorities. Specific income thresholds may change annually and depend on the sponsor's household size. The sponsor's income should be at least 125% of the federal poverty guidelines for their household size. Affidavit of support, Form I-864. The financial sponsor is required to complete and sign an affidavit of support, Form I-864, for their spouse. This form is a legally binding contract in which the sponsor agrees to provide financial support to the immigrant and ensures that the immigrant will not become a public charge in the United States. Proof of income. The sponsor must provide supporting financial documents, such as tax returns, usually the most recent 3 years, W-2 forms, and recent pay stubs, to demonstrate their income. Household size. The sponsor's household size, including any dependents and the intended immigrant, is considered when determining if their income meets the minimum requirement. An arrest or conviction record of a spouse or fiancé applying for a K-1 or CR-1 visa can have significant consequences and may affect the eligibility and outcome of the visa application. The consequences can vary depending on the nature of the arrest or conviction, the type of visa being sought, and the specific circumstances of the case. Intent to marry. Both the sponsor and the fiancé, Must have a genuine intent to marry within 90 days of the fiancé entering the United States. Other resources. USCIS website. USCIS is the main government agency that processes immigration applications in the United States. U.S. Department of State is the federal executive department responsible for conducting foreign relations and promoting diplomacy with other nations. It's a crucial part of the U.S. government. Your engagement matters. If you found value in what you've seen, please give this video a thumbs up and consider joining the Love Train Nation by hitting that subscribe button. Your support drives our mission to keep you informed and inspired. Thank you for watching. Until next time, stay curious, stay informed, and let's keep riding the love train together. We'll see you in the next video.